for the indulgence. I want to start with my colleagues who were kind enough to oblige me so that we are able to start at this time. And for you, Council, to come in, I don't want to take this for granted. I want to thank you most sincerely for that recommendation so that we are able to start these proceedings at this time. As you know, because of the limited time, we may, on some other days, have to sit late, and I want to seek for the indulgence of all of us. Now, ladies and gentlemen, everybody knows that this is not an ordinary piece of litigation. It's not an ordinary piece of litigation. We all are aware of the time constraints, and unless we cooperate, we will have problems. So I want to seek your indulgence. I want to seek your indulgence, all of you, that when we start, first and foremost, let us have respect for each other. Absolute respect for each other. Let us conduct these proceedings soberly. I know the emotions of your clients. I don't want Council to descend the arena of the clients, so that we are able to conduct the court business the way it is supposed to be conducted, with decorum, and as I've said, with respect for each other. And then we'll move on fairly smoothly. That's why I said, please don't bring in any emotions from your clients. We are not here in a campaign forum, so let us restrict ourselves and deal with the matters that are before us. This evening, we have several applications. We have applications for people who want to be joined as amicus. Who are the parties who want to be joined as amicus? Once again, just the Honorable Attorney General, the Honorable, the LSK, Mr. Kanjama, and who else? Mr. Njenga. Yes. We will deal with those applications and give rulings tomorrow. Now, we have applications by parties who want to be joined as interested parties. Mr. Kinyanjui, your client, Mr. Mutuma, for Mr. Court, and yes, we will also deal with those applications and give our rulings tomorrow. This evening, we want, before we go to the pre-trial conference, there are two applications. Two applications seeking to strike out certain pleadings. Who are the applicants in these applications?
My Lord, may I, with your permission, for the avoidance of doubt, ensure that we have understood you. When you say, my Lord, that you will deal with the amicus application, does my Lord mean you do not wish us to make oral submissions? Because my understanding of the rules is that you could do, it is within your discretions, my Lord, to make that ruling without necessarily hearing the parties. And I want to be sure that I've understood you.
Very well. The applications have said we are going to give rulings tomorrow. We will deal with them on the basis of the pleadings and the replies.
I'm most obliged. I'm most obliged.
So those ones, we are not going to allow any oral submissions.
Most obliged.
The ones we want to allow fairly short oral submissions are the ones seeking to strike out pleadings. Who are those who are seeking to strike out pleadings?
My Lord Chief Justice, my Lords, the third respondent filed a motion seeking to strike out certain pleadings filed by the petitioner.
Yes.
The application has been responded to. We are ready and able to make very brief submissions in respect to that motion.
Very well. Which is the other application?
The opposite, an application by the petitioner, you say.
There's who is the applicant?
Yeah, we also have an application to strike out the
yes.
responses from the respondents. That application will, on our behalf, will be prosecuted by our learned junior, Mr. Wele.
Yes.
Yeah.
We have looked at those applications, Mr. Ngatia, Mr. Orengo, and Mr. Awele. The main ground is that those pleadings were filed late. Am I correct?
Yes, it's served late.
Huh?
Served late, my lord.
Served late. Whose was filed late? It is only service. It's only service.
My Lord, the applications by the petitioner to strike out the submissions by the first and the second respondents, which submissions were filed on time, the only ground on which they are seeking to strike out excuse me, those submissions
Is the microphone on?
is on the basis that our submissions were served out of time. And I think you will notice from our response that our submissions were filed at 11 p.m. at night. We proceeded to the offices shown in the records here as a place for service of the petitioner, and we found their offices closed. We were there before midnight.
Very well.
So
Don't argue the application yet.
No, I'm
yes.
just pointing out
yes.
that is the nature
yes.
of the matter.
Yes.
We filed in time.
Yes.
We sought to serve on time,
yes.
but the offices were closed.
Yes. Now, our question is this, Council. You can't consent to this so that we are able to move rather than spend time on arguing whether or not an application or a pleading that has been served out of time should be struck out. We go and make rulings.
I wish I could make it easy for the court, but on our part it's not possible because certain pleadings have never been served to date. They were not served in time. Even if we were requested to take them 2 or 3 days thereafter, we would have done so. But until to date, they have never been served.
Which ones are those?
They are on the face of the motion.
Yes.
We have tabulated each one of them. There are 2 sets of pleadings that were not served, then pleadings that were served on a Sunday afternoon without leave of court, and again, those have never been served on us. So it's not possible for us to consent on those things. If a request had been made by counsel, I would have been the first one to say yes, let's extend time to counsel.
Yeah, but the request is now coming from court.
Lord, our position
yes.
is that we'd rather let every pleadings filed be allowed. That is because going through our brief is not quite correct that they filed in time and served on time. And we got evidence to show that that was not done. But because of the nature of this matter, we would rather everybody is fully heard, the responses are fully taken into account, there is nothing to fear, it's all about what happened and the law.
My Lords, I'd like to request you to take the speech made by the Honorable James Orengo to apply it to my own application.
But my Lord, when it's admitted, I will have no problem.
My Lords, Your Ladyship, we have one difficulty in going along with the suggestion made by my Lord the Chief Justice. Because the application we have made, that is the first and the second respondent, to strike out 3 volumes filed by the petitioner. Those 3 volumes relate to evidence, additional evidence, filed outside the constitutional limit of 14 days. So that is a difficulty that we have.
Very well. Very well. That being the case, Council, we want to start. We'll give you 10 minutes each. 10 minutes each, strictly 10 minutes. And as I said, please let us have a cooperation. We have your applications. We'll look at them. Let's see who starts. Who is seeking to strike out the pleadings by the petitioner?
We are, and our application will be argued by Issa Mansour. Well, we've been told to address the truth. Yeah.
Yes, Mansour, you have had 10 minutes.
Yes, Lord.
And please stick to that.
Yes, Lord. We filed a notice of motion application dated the 25th of August 2017. We've served it on all the parties. Lord, on the face of it, we seek to strike out the following documents. The affidavit of Dr. Edgar Ouko Otumba, sworn on the 25th of August 2017. The affidavit of Norman Magaya, in support of the petition, sworn on the 23rd of August 2017 and filed on the 25th of August 2017. There's a supporting affidavit of Omar Yusuf Mohammed, sworn on the 24th of August 2017 and filed on 25th of August 2017. And lastly, a supplementary affidavit of Ogla Karani, sworn on the 25th of August 2017 and filed on the same date. The reasons we seek to strike out this affidavit is that the petitioners filed a petition on the 18th of August 2017 within the constitutional time prescribed of 14 days. Sorry, within the time prescribed for filing the petition pursuant to Rule 6 of the Supreme Court Presidential Election Petition Rules 2017. But the petition is defined under the rules to include an affidavit required to support the petition. And Rule 10 provides that the petitioner shall, within 2 days of filing the petition, serve the petition upon the respondent. Now, in terms of these affidavits, we had already first responded to the petition, having been served on the 20th of August with the petition and the original supporting affidavits. But these extra affidavits were filed outside the time prescribed for filing the petition together with the supporting evidence in the affidavits. And more importantly, they raise new issues that we have had no time to respond to. There is new causes of action, and they contain additional evidence that change the nature and the character of the petition, and it will prejudice both the first respondent's ability to respond to this affidavit as the pleadings have closed, as well as the second respondent, the chairman of the IEBC.
When did you say you were served?
With regards to the first affidavit of Dr. Edgar Ouko-Tumba, it was served on the 25th of August 2017. Norman Magaya, it was also filed and served on the 25th of August 2017. Omar Yusuf on the 25th of August 2017. And lastly, the one of Ogla Karani on the 25th of August 2017.
So they were all served on 25th?
On the 25th, yes. They were sworn on different dates.
Yes.
But served on the same date.
Okay.
So, my Lord, for those reasons, as the first and second respondents will be prejudiced, they cannot respond to these affidavits in terms of replying by affidavits sworn on behalf of the first and second respondents, and more crucially, we had already filed our submissions and response to the petition within the timelines stipulated under the rules. And Lord, because they go towards prejudicing our client's right to a fair hearing, and no reasons have been advanced why they could not be filed within the stipulated time, Lord, we urge you to strike out these affidavits. They have been filed out of time, and the petition should proceed on the basis of the evidence that was tendered within the constitutional and statutory time prescribed by law. That's all, my Lord, unless you have a question.
Thank you very much, Mr. Mansour. Who is next?
My Lord, Mr. Otiende will respond on our behalf.
Sorry?
Mr. Otiende will respond on our behalf to that application.
Yes.
If it may please, my Lord, 3 quick responses. That application, my Lord, is based on a misapprehension. All the 4 affidavits spoken to are not filed in support of the petition, but they are filed in support of the application by the petitioner, which my lords are yet to hear. That is the application seeking various interlocutory reliefs. My lords will look at page 10 of that application, and we'll see that all those affidavits mentioned by Raila Odinga, Omar Yusuf, Dr. Edgar Ouko-Tumba, Nyangasi Oduor, Norman Magaya are in support of the application, not the petition yet. Second, my Lord, when we prosecute that application, as is clear in prayer number 7, we shall seek leave that other than being filed in support of that application, that this court be pleased to grant leave that those very documents also be filed in support of the petition. That has not come. Therefore, the objection is misplaced. Second, my Lord, the reason we take the position that Senior Counsel Rengo indicated is that if we start looking at who filed what document late and served late, almost all the pleadings filed and served by the respondent will be struck off. Either because, one, my Lord, that the very application to strike out was itself served out of your direction. It was served after 1 p.m. when the directions required that all interlocutory applications be filed before. That all the responses, as indicated by Senior Counsel Mwite, were not served within the time prescribed. the question of whether the which office was closed will invite us to cross-examine senior counsel Mwite as to whether he appeared in that office or not. So we were taking the easier option of saying let all these documents be admitted and we go to the substratum of the matter. And last, my lord, that our overall position is to go to the substratum and not to invite this court to fall into the trap that is being set of going on technicalities rather than substantive justice. That is our response.
Thank you very much, Mr. Omolo.
My lords, we have two applications before you, both by notice of motion. The first one, court stamped 25th August this year. As regards that application, 25th August this year, there are two very, very unfortunate incidences or factors. In respect to the first set of documents, while we were served with a petition on Sunday was 20th August, perhaps I could let...
Your time is running.
We were served on 20th August at 5:15, while being served, and I hope this is common ground, it must be common ground, certain documents were not served. And those documents are tabulated in prayer number 1 in the notice of motion. Those documents have never been served to date. So, my lords, I would have taken the olive branch if they were served on Monday or Tuesday. The position is they have never been served to date. And those are the documents in prayer number 1 in our notice of motion. In the same notice of motion is an incident that took place. On Sunday 20th, petitioner came to your registry at 1 p.m., procured a clerk to accept documents tabulated in prayer number 2, and they were...
Mr. Ngata, by procured a clerk.
No, cost. I think cost. Yes.
Procuring.
Will be that scientific, my lord, henceforth. Caused a clerk to stamp the document 18th. And I'm saying this not as something I am aware of. I became aware of it from the letter by your registrar. There is a letter from your registrar to that effect, that those documents were backdated 18th instead of the date that they were presented. Once again, my lords, I'll be the first to have indulged counsel if a request was made for an extension of 1 or 2 or even 3 days. But to cause a document to be backdated, coming from my legal training, is not the correct way. We should be priests at the altar of justice. We should be doing that which is correct instead of backdating documents. On the basis that those documents were backdated, my lords, we would urge that they be expunged from the court record. That's the first notice of motion. Second notice of motion, court stamped 26th August. After the close of pleadings, 5 new affidavits were filed by the petitioner, 5 new affidavits, raising new evidence. That evidence, my lords, under the rules and the protocol you have established, we have no time to respond to it. And these are 5 affidavits. So once again, my lords, we find ourselves at a very awkward position that new evidence has been tendered. It should have been tendered with the petition. Our time for response has expired. And without any leave, and without even any indication that leave would be sought, with a corresponding increase for time to be given to us to respond, a petitioner has again caused the registry to accept pleadings or affidavits which would be very prejudicial to our client. So, my lords, will see the difficulty that I have, a difficulty which is a real difficulty. If these affidavits remain on record, I do not have the opportunity to cause my client to respond to them. There will be a real prejudice, not apprehended prejudice, but a real prejudice. Equally, if the first set of documents are again accepted to remain on record, there is a real prejudice to the third respondent. My lords, we have filed submissions in respect to both applications. Would urge you to allow them as requested.
My lord, with your permission, again I'll respond to Malan and Friends' application. My lord, the application being prosecuted before you was filed yesterday, itself after 1 p.m. If we were to go by Malan and Friends' implorations on time, the application itself ought not to be had, given your directions that all interlocutory applications were to be filed before 1 p.m. That is the first point.
What time did you say it was filed?
It was filed after 1 p.m. and served at 4:50 p.m. My lord, the second point is that Malan and Friends' application, unfortunately, again, is a misapprehension and a misconception. My lord, Dr. Nyangasi Oduo has two affidavits before you. There's his initial affidavit and a further affidavit, all filed and served in time. My lords will notice in the schedule prepared by your registry that the first affidavit appears as number 4. The further affidavit appears as number 14. Both were filed and served on the respondents, and that they have not disputed. The misconception, my lord, comes in the annexures. The first affidavit has annexures DNO 1 up to 7, and they are marked in volumes. The second affidavit has two sets of annexures, DNO 1A to Z. That is the annexures to the second affidavit. Malan Senior obviously looked at the annexures to the first affidavit and only saw DNO 1 to 7. But the ones that he attacks in paragraph 1C is not only one, my lord. It is DNO 1 2A to 2Z. And they're in volumes which each of my lords, I'm sure, have. They're marked from number 1 to 64. The second set is in the further affidavit, which Malan and Friends attacked at part D and E. It is marked in the further affidavit as DNO 2A. The only indulgence that we are going to seek, my lords, in that respect, is that the typographical area for DNO 2A was to read 3A only. But the documents and the volumes were filed and served in time, and they support the further affidavit.
So you say the only thing you are seeking is what?
my Lord, to correct the typographical error in paragraph 5 of Dr. Nyangasi's further affidavit, where it refers to the second annexure as DNO2A. It should be DNO3A2U. There are 19 volumes, all of which were filed and served in time. My Lord, lastly, the documents that we have referred to were all filed, served in time, and the evidence for that, my Lord, is not even from us to provide. The evidence that each of my lords will find that the documents referred to were with you. It is inconceivable, my Lord, that we could have sneaked into all your chambers and sneaked in documents as suggested by Malani Senior. Thank you, my Lord.
Thank you. Thank you very much.
My Lord, I believe there was our own application to strike out which our learned friend Mr. Wele will prosecute.
Thank you, Your Lordships. My Lord, ours is a notice of motion application dated 26th of August 2017, principally seeking the first two prayers on the face of that application. The first prayer being, my Lord, the striking out of all the documents that were filed by the first and second respondents on the petitioners in response to the petition, and they are set out on the face of the application. And the second prayer being for the striking out of all the documents that, I beg your pardon, my Lord, the first prayer being for the striking out of all the documents that were served in response to the petition by the third respondent, and the second prayer being for the striking out of all the documents that were filed by the first and second respondents on the petitioners in response to the petition. My Lord, the application is premised on Rule 17 for the avoidance of doubt of the Supreme Court Presidential Election Petition Rules that permit any party wishing to file an interlocutory application to do so 1 day after close of pleadings. And that day was the 26th of August 2017. The substance of the application, my Lord, is premised on Rule 11.1 of the Presidential Election Petition Rules, which basically require any person wishing to file any response to a petition to do so within 4 days of the filing of the petition. My Lord, the petition was filed on the 18th of August 2017, and the same was served on the respondents on the 20th of August 2017, well within the time prescribed by the rules. My Lord, we were, however, served with the responses, all the responses that have been set out on the face of the application on the 25th of August 2017, well outside the time stipulated by the rules for service of answers to the petition and all affidavits in support of the same. My Lord, the answer that my learned senior counsel Muite attempted to give for the late filing does not sufficiently address the reason why the same was filed out of time, because even though our office may have been closed at 11 p.m., my Lord, the rules required the respondents to file and serve within 4 days.